Hello, and a warm welcome to everyone joining us for this joint Taylor Wessing Wilson Sonsini webinar. In this session, we're going to be discussing recent trends in university skill terms. And Kathy has just mentioned that on the front page, right on cue of the Wall Street Journal this morning, there's a big article about allocation of commercial returns from the Oxford vaccine, where a dispute seems to be brewing between the academics, the spin-out company, and the university. So right on cue, we've got a very topical intro to the issues we're going to be talking about today. My name is Adrian Tatunji, a transactional IP partner at Taylor Wessing, based in our Cambridge, UK office. And I'm really pleased to be joined by a stellar panel of experts who are going to be joining us from all over the world, in fact, and sharing their insights on these topics this afternoon. So let me introduce them in turn. On the screen, you've got first Kathy Koo. Kathy is now the Chief Licensing Advisor in the Palo Alto office of Wilson Sonsini. She's a member of the Technology Transactions and Patents and Innovation Practice groups there too. Kathy will be known to many of you as an internationally recognized leader in the field of technology transfer. She served as the Executive Director of Stanford University's Office of Technology Licensing for 27 years. And during that period, OTL licensed hundreds of new technologies, bringing in over $1.8 billion, most of which went back to the university and the faculties to support research and education. I think for me, just two highlights to mention were the very successful non-exclusive licensing program of the foundational Cohen-Boyer recombinant DNA patent, which I think Kathy generated over $250 million before the patents expired in the late 90s. And then, of course, there was the Google cash out when Stanford sold its equity stake in Google following its IPO. And I think that was back in 2005, which again raised a good chunk, about $350 million. Tony Raven, then moving on to Tony. Tony will be equally well known to many of you. Tony is the Chief Executive at Cambridge Enterprise, which is the University of Cambridge's Technology Transfer Office. He joined after a long history as a successful technology entrepreneur, including as the co-founder of Summit Technology, the pioneer of laser refractive surgery, which was ultimately acquired by Nestle Alcon in 2000 for, again, something like $850 million. He oversees a portfolio of 100 active spin-outs, with Enterprise spinning out 10 new companies and generating $20 million in licensing revenue in 2019 alone. I think during Tony's tenure, spin-outs in Cambridge Enterprise have gone up by 250%. So a really remarkable track record there. And then last but not least on the panel, we have Jamie Kazabowski. Jamie is a venture associate at RA Capital Management, which is a Boston-based multi-stage investment manager. And they're dedicated to evidence-based investing in public and private healthcare and life science companies in particular. Jamie's responsibility is to identify compelling assets to help new company formation. And he previously focused on early stage biotech investing as a director at Boehringer Ingelheim's venture fund, where he acted as a board director of early stage companies on both sides of the Atlantic. So Jamie should be able to bring and will bring to the discussion today a really interesting perspective of investor behavior and startup behavior on both sides of the Atlantic. So today we are aiming for a fairly free-ranging discussion. Let me reverse the slides for a minute. This is our only slide. We're going to aim to cover at least the issues on this slide. However, we do want the session to be interactive. There's Q&A functionality on the screen in front of you. So if you've got any questions as delegates which you'd like to raise, then please use that functionality. We will try and take a selection of questions, the most common, in the course of the webinar and in the Q&A slot at the end. Any others which we don't manage to answer in the course of the webinar, then we will try and follow up with you afterwards. There'll be a short survey at the end of the session as well. And as always, we'd be grateful for feedback. And then just to reassure people dialing in, you're not on video or audio, so you are muted centrally. And then finally, the usual caveat, we can't deal with questions specific to one company, and the contents of this webinar are not to be taken as legal advice. So with that, let's get going. The first topic we're going to look at today is the vexed topic of university equity stakes. What is market, and will universities accept higher equity stakes in lieu of no, or at least lower, financial payment obligations in the license terms? And just by way of background, I think, to this topic, there was a survey published in Nature Biotech Journal in 2015, which set out the approaches of a large number of US and UK universities on the issue of equity stakes. And on both sides of the Atlantic, what was really striking was the diversity of approach. In some cases, universities take only 5 to 10% equity, and in other cases, they push for 60 to 70%, or in one case, even 100%. And it was noticeable that universities in both countries, which ranked highly in terms of commercialization income, tended to be at the low end of the equity range. There were exceptions, and that wasn't uniformly the case. So I think this diversity makes it quite difficult for an academic founder and their investors to benchmark a university term sheet and work out whether the terms they've been offered are on market or whether they are off market, and in particular, whether they're getting a good deal or not. So Tony, can we turn to you first? And what are your thoughts on why we are seeing this diversity of approach of universities?
Sorry, just on mute, usual problem. I think there are a couple of main factors behind this, and sort of invite Kathy to sort of chip in, because we've talked about this a lot, particularly in the differences between Stanford, MIT, and UK universities. One is the level to which the university wants to be engaged in equity. In some cases, I think it's universities prefer not to be involved as a shareholder, keep the equity percentage low, and in others they want to. They're actively involved and don't mind higher equity stakes and all the shareholder responsibilities that come with that. But I think when you look at those two main models, low versus high, it's not quite as cut and dried as you think, because often the low equity stakes come with anti-dilution provisions, which require that the shareholding isn't diluted until a certain amount of capital has been raised or a certain round of investment has been reached. And when you factor that in versus the full dilution of the higher equity stakes, they become a lot more comparable. The other factor that comes into it is just how much work the university needs to put into making this happen. With Kathy in Silicon Valley, there is the world's leading ecosystem surrounding there, full of entrepreneurs, venture capitalists, facilities, premises, everything you need to do a startup. And the university's role, or the TLO's role, is much less to do with helping getting the company started and more to do with licensing the technology into that company. Whereas Cambridge is probably the premier ecosystem in Europe. But even in Cambridge, we don't have that ability. We have to do a lot more work with our academics to help them put the company together, get a business plan written, raise the finance, find the management, all those activities. And when you're doing a lot more, sort of, we as universities, as quasi-public organizations, we can't subsidize people's spin-out companies. We have to make sure that what we get is commensurate to the effort put in. There are a couple of other things which go in, is the split between equity and royalties. Some people take full royalties, no equity. Some take equity, no royalties. Some people take a mix of both, and that obviously affects the percentage you want to take. And then there's all the intimate details of the company itself. You can be dealing with a postdoc who's come in 6 months ago, been given a project by a research group which has been working on it for 20 years. And they are making a massive contribution versus somebody who's been working on this solo for 20 years on their own and basically put it all together themselves. And making sure that everyone in that equation is equitably treated is important as well.
I think Tony raises a perfect point that universities have a different attitude about equity because of their involvement or lack of involvement in helping to start the company. At Stanford, I've often said that we are in this amazing entrepreneurial ecosystem, And in general, when I was director of the office, we did not have to help startups start at all. And so we didn't help with the business plan. We didn't help really with even introducing investment capital. We didn't need to be involved in putting the management together or anything like that. At Stanford, I used to say it was more Darwinian. If you could figure out how to do it, then maybe you should start a company. If you can't figure it out, then maybe you shouldn't start a company. So it was much more laissez-faire sort of attitude at Stanford and MIT. I don't think MIT had to help their entrepreneurs at all. Many, many universities in different regions of the United States still do need to help their startups, and they're encouraging startups and they're supporting them. And those offices are much, much more involved, and therefore they do feel like they deserve a bigger stake in the company, the equity. With that said, I think there are some universities who, I know Georgia Tech, for instance, once only did equity deals and now don't do deals involving equity at all, because the view of equity really depends on, again, where you're sitting. Most universities in the US, and it's just a generality, make more money on equity if it's sort of a software deal, but if it's a biotech life sciences deal, the bigger money usually comes with earned royalties. Not always the case, but mostly if there are sales of a product, that's where the big income comes. And as Tony mentioned, we do usually have an anti-dilution provision where we're not diluted up to some round of funding. It can be $5, $10 million. It can be as high as perhaps, $20 million. But there is a factor where the university says, the company has to maintain the percentage up to a certain amount of fundraise. So I think it's really an attitudinal thing. When you're dealing with a university, talk to them and find out how they view equity versus earned royalties.
That's interesting. So do you think that means, Kathy, that for a life science startup, for example, a spinout, the chances of getting the university to take higher equity stake in return for lower milestones and royalties are less than with a software-based spinout?
Well, we've done deals, from the Wilson side where we offer more equity and then are able to get a lower earned royalty, but it has to be viewed as a package. Most universities will say it includes equity and it includes earned royalties. Most universities realize that equity and its cash out is not under the control of the university, and often it's just determined by the market. The market does well, then the equity is worth something. At Stanford, in my tenure, Google, of course, was a huge equity cash out, and many of the physical science companies had, larger cash outs. We've had a few biotech cash outs that were, notable. But again, in general, the equity value will be more in the physical science kinds of fields than in the life sciences.
And why is that, Kathy? Is that because the university stake is likely to have been diluted down in life science companies because of the capital-intensive nature of their business model? By the time you get to an IPO or an exit, the university stake is much smaller than it might be the case in a physical sciences or software-based startup.
Yes, and a lot of physical science startup software companies can go public sooner. It takes a really long time for a life science biotech often, to go public or be acquired.
Sure. Jamie, can I bring you in now at this point and ask, what are you seeing when you were doing investing either in Europe or in the US from an investor's point of view? What were your attitudes to high equity stakes versus the financial, the commercial terms and the license?
Yeah. Yeah, you brought up a good point on the last discussion point, which really is that the road to actually getting a return on investment in biotech is just so much longer and so much more expensive than tech tends to be. So you'll typically find that by the time you IPO or you're acquired and your shares are actually worth something, you've had to put in somewhere between 20 and maybe $500 million. So you're definitely, it's labor intensive. So it's always good to get some equity, but it's really not the value driver when it comes to, I wouldn't fight too hard to maintain, double digit equities over a very long period of time, because you'll actually probably find that it's a rate limiting step. When I say that, if the cap table is a little bit too shifted, it's not going to be appealing for investors or myself to deal with a university that is not contributing any capital, which is what the company needs now. I know that the technology and the know-how is the secret sauce of the company, but the real driver is capital. So you have to be able to raise capital, and you don't want to be, I guess you don't want to be turned off by a cap table that doesn't make sense. If a university has such a high equity stake and isn't contributing capital, that means that when I put more money into your company to buy equity, I'm getting less of it, which is never attractive. And I'm not trying to say that there isn't a balance. You're more likely to see actual financial returns on the financial milestones from getting into a clinical trial or actually being commercialized. So I would, I'm doing myself a disservice on this one, but don't fight for too much equity. I will say I would fight more for the milestones on the back end, because those are for sure set up to be given, and the equity is, it has no value till it has value, so it's hard to know in the very beginning what the value truly is. So the trend in the US is typically somewhere single digits, high single digits to low, just depending on how mature the asset is. I'll say Europe's a little bit more conservative, where you may be closer to low double digits in biotech. But that's also kind of a sign of the times that, I think the technology and the rate that things are spun out in the US is just so much quicker. So things are baked less, they're less mature. And, investors like myself are the real driver of enabling it. Whereas, I think the assets are more mature and probably garner a higher valuation or a higher equity stake in the very beginning.
Interesting. And Jamie, sometimes it's said that investors don't mind about equity stakes because it's really an issue between them and the university. It's an issue between the academics and the university and doesn't affect the investors. But what you were just saying suggests that actually investors are concerned perhaps about the disincentivizing effect on the founders if the university takes too high an equity stake. Is that what you're seeing?
It could be. You just don't want it to be inconvenient. The cap table is the most sensitive thing in a healthcare investment. And you don't want something to be unpalatable. I would say most of the time we can come, if all parties want to align, we can come to an agreement. And typically, if it is too high, we'll renegotiate it to put it into perspective. But if you think about it, if we're going to come with the syndicate that's going to put in $100 million into a startup, we want to make sure that we're getting the proper amount for the valuation and the proper equity stake for the amount of money we're putting in. And unfortunately, unlike everything else, the cap table is 100% of a pie. There's no way to create more of it. There is always 100%. So if it's a zero-sum game. So it's rare, but you just don't want to be off-putting or too, you don't want to see any funky cap tables where it's like, a university has 50% of the equity. That's insane, just because if you think about it, that's diluting you down to a point that it makes it an untrackable investment from the financial standpoint.
Interesting. Tony, were you coming in? Did you have something you wanted to add there?
Yeah, and I was going to add to that because I think it is when you look at the Nature article you quoted, that is the split between the academics and the university and the department, research department they're working in. And I always see that as sort of as a very early stage thing to get sorted out between you and the academics who are involved with the company, is what is the right split for there, given the circumstances. But then it's a case of going unified to the outside world, and there, like any startup, it's the market plays the rules. What dilution do you take for the money you're taking in? And I don't think that's really any different from any other startup. All that we're doing in the early stages is either through policy or negotiation with the academics, setting the internal starting point of the division, and then we both obviously want to maintain as much as we can. But I think a couple of other points. One is that there is a difference of objectives here. Primarily, the universities are interested in creating the best possible impact from the research for society that they can, and the investors are looking to make the best return out of their investment that they can, and those are not necessarily the same objective. Kathy and I are very fortunate that we work in offices which with universities who are very well endowed and can be quite relaxed about sort of the cash coming in. If you are in a smaller office, though, there is the pressure to at least try and cover your costs. So just giving everything away is not going to be a career-enhancing decision that you make. So I think it is important to recognize that different offices have different drivers, but we're essentially trying to get it out there. The other thing with the equity is that the companies in Silicon Valley tend to be rather well financed out of Sand Hills Road, and so they have cash to pay things like license fees and royalties, etc. A lot of the companies out there are not, and there's the famous phrase, they are equity rich, cash poor. So in that case, the last thing you want to be doing is taking cash out of these companies, and that tends again to bias you towards wanting to take a bigger equity stake, because at the end of the day, universities want the impact, but we would like to see that our academics and the university get a fair share of the rewards of success for having done the pivotal catalyst that get these companies going.
You mentioned, Tony, covering costs for the TTO, for the Technology Transfer Office. Do universities typically rely on the equity cash out, or is that too contingent and too long term, and they have to focus on upfronts and milestones, technology access fees, those type of things in order to cover their costs?
Well, I think the more you are driven towards covering the costs, the more you need to do that. At Cambridge, we're lucky. Basically, we take equity and our royalties are a downstream tax on sales without a lot of upfronts when we're dealing with spinouts, because we can afford to do that. But if you can't, if you're sort of struggling to cover the cost of running your office, those upfront payments, minimum annual royalties, milestone payments, etc., become a much more important component. And it's important that we get that balance right, because if we don't, then we start to lose this whole machine, which is creating so many valuable companies for our economy and our society for tomorrow. So we do want to keep the machine sort of healthy. It's a bit like any commercial negotiation. If a supermarket goes to its suppliers, if it drives the prices down too low, its suppliers go out of business. That's not a viable option for the supermarket in the first place.
Tony, you made a point a few minutes ago about the link between non-dilution and the university equity stake. So that's a good segue, I think, into the next topic about non-dilution. And we've also had a question about preemption rights and whether universities care about them. So, Kathy, can I turn to you and just ask you what you see in the US market when it comes to non-dilution? You've already touched on that briefly, and preemption rights.
As I mentioned earlier, universities will typically take a percentage, maybe 5–10%, and then be not diluted up to a certain amount, maybe $10 or $20 million to 20, let's say. And then many, over 100 universities in the U.S. do care about preemptive rights. There are various organizations that will either acquire those preemptive rights from the university and invest on behalf of the university for the university, or at Stanford, Stanford had a fund where we could invest directly into the company when the opportunity came up. So usually many of these provisions allow for the university to buy more equity at a rate of something like 10% of the round. I think most universities are starting to be focused on that and interested in investing actual real cash.
And it sounds like non-dilutes are quite widely accepted by the investment community in the US. Jamie, is that your experience? Is that what you see as well?
They can be. It just depends. It's all balanced. So you will have to take dilution at some point. I think I haven't seen any deals, or I specifically personally haven't been involved in any deals that had permanent non-dilution. It usually had a cap non-dilution or X amount, until $25 million raised, the equity is non-dilutive at some lower level of equity. I'm okay with doing deals like that. At some point, you will have to get diluted, just because, again, you don't want to be the issue on the cap table. So you have to balance and realize what your technology is, how mature it is, how much work is going to have to go into it, and really be honest with yourself, your university, and the users themselves about, what is the stage of the technology, how much work is going to have to go into it to actually get it into the clinic. So, it's always that balance. You can take very high equity in the beginning with no dilution protection, but you have to realize you're quickly under the first round going to be diluted down to a much more reasonable level. Or you can take a lower level and have protection just to kind of spread it out over time, just so you guys aren't completely hammered in the beginning, just because, that transition from the university into a new company is, to be honest, where the university has the most influence. Not only that, but like the technology is also, it's critical to keep that relationship going. If we go 5 years down the line and we've taken, the technology or the compounds you've made, and we've really put, $25 million worth of research into it to make it something that went to the clinic, yes, so we've added a ton of value outside of what you guys initially discovered, and you guys should value you should take the dilution in kind, with realizing that the investors in the truly have been driving the later stage development. So it's all a balance. I would say in the very early days, you can do non-dilution but have reasonable caps, or just have a higher range in the beginning with no dilution. Bet against myself, I would say take the dilution protection and try to get that out as long as possible, just because what we do is so long and it's so expensive that you will eventually be diluted as, down to a very small number. It may not, truly represent what you think the value is. So you can definitely be a little strategic how you play that one.
Thanks, Jamie. And Tony, what in terms of the UK, I think you have a different experience. What do you see going on in the UK? You're on mute, Tony.
Yeah, in the UK, there's been quite a bit of agitation for going on a model similar to Stanford with non-dilutes, and one or two universities are trying that out. Our experience at Cambridge is we've tried it twice, and in the next round of investment, although we had the non-dilute there, and I totally agree with Jamie that it needs to be a limited period or cap non-dilute. But in both cases, before we got anywhere near that, the next round investors said, well, if you want the money, get rid of it. And as universities, we are not going to sort of play back to Jamie's generosity early on. We're not going to kill a company over an issue like that. So we also, because of this, we did a survey amongst, just an informal conversational survey with a number of the VCs that regularly invest with us, and out of that came sort of the majority would not accept it. A few could live with it, one or two were fine with it. So I think, I don't know, there's maybe a different sort of cultural thing on the opposite sides of the Atlantic over non-dilutes, but we're going into sort of trying that out here.
I'll add the caveat that have the non-dilute end by the end of the round, and the next round not have it be grandfathered in, because that would be something that would be a sticking point if you didn't max out the cap in the beginning. Just because I'd probably go back and say renegotiate, because I'm new money in, I'm not old money.
Yeah, but if your non-dilute is on the seed round and the A round they say get rid of it, it's not a non-dilute, it's a dilute from the beginning.
This is Kathy. I wanted to mention that for universities, I used to stay at Stanford, we can't live on equity alone. And so the attitude when I was there is that equity is sort of icing on the cake and cash still is king. And we hoped to be self-sufficient. And so again, the equity cash out is so unpredictable that we always wanted, upfront money, annual payments, et cetera, because cash is real and equity is still a little bit of monopoly money.
Yeah. But I think going with that, it's important that the data in the US, the AUTM data, is that about 87% of tech transfer offices in the US over a 20-year cycle lose money.
Yeah.
Right.
So basically, it ends up being an activity subsidized by the university.
Interesting. So on this point, we've had a question from Dan Rook at the Start Codon Accelerator here in the UK, where he's saying that if a university asks for non-dilute, how would universities feel about other initial investors, so particularly seed investors, benefiting from them as well? So Jamie, maybe this is a question for you, because in the US, where university non-dilutes are more prevalent, what is a later stage investor's attitude to a seed or other early stage investor having non-dilutes as well?
Oh yeah, I'd be chomping on a bit to get renegotiated. They should be reasonable, but if other investors have kind of also grandfathered in the non-dilutes, I better have a very, very strong reason why they should retain that protection for the later rounds. As always, I'd love it if I'm that first money in and trying to protect myself. I probably wouldn't put it in because it would be a very odd thing to see and instantly probably toss the brakes on, or at least have a real sticking point to negotiate the next rounds of financing. I could possibly see that with founders or someone who's not a financial investor. But if a financial investor has a non-dilute, it feels a little Mickey Mouse. I don't know what to do. I would say if you really have conviction, you should be willing to invest at a pro rata rate, more money to earn more equity instead of just trying to protect the stake that you had. But I'm also coming from a giant fund that has the luxury of, paying the value to own the equity we want. That's not always the case with angel investors or others, but typically favored nations usually comes into play at some point. That all the investors should be considered, at the same level, just so everyone plays nice. If you start playing some of these weird, rights to different classes of shares, it just makes for a really bad board and just bad tension going forward to help the company succeed, which is what everyone wants.
Sure. And Tony, just a final thought before we move off this topic. of non-dilutes and preemption rights. University preemption in the UK, is that something that you're seeing more of? Is that something universities push for typically?
I think it's pretty standard. The question is, do universities have any capability to do anything with them? And certainly ourselves, Oxford and others do, because we have our own funds and partner funds which can take up those preemption rights on our behalf. And for us, that's important because if you cease to have a seat at the table, then you get forgotten. And one of the major things I think is that we're more concerned about is cram down rounds and also preemption stacks building up, so that you end up at the bottom of the queue. And I think we have been through a period where academics created very successful companies and got very little out of it. The classic being BioVex, where the founding academic created $1 billion biotech and made $709 from the exercise. We need to get past that if we're going to get our academics to want to play in this game and become serial entrepreneurs, that they need to see a fair and equitable return for what they've helped create.
Sure. Well, this is a fascinating topic and one that I think we could go on talking about, but in the interest of covering our other topics before we come to the end of the webinar, if we leave it at that point, we may come back to it in the Q&A at the end, but move on to what I think is a shorter point and a more focused point about upfront fees, technology access fees, or just historic patent costs. What are there any trends, any comments that you can make? Kathy, what did you see when you were at Stanford, and what are you seeing now?
I think most universities, the deals that I'm seeing now, are being really reasonable with upfront fees. They're usually $10,000, $25,000. Again, it depends on how many intellectual property assets the startup is acquiring. But I think universities recognize that startups are cash poor, and so that's why they want to sort of backload the deal. In a biotech deal, there will be milestone payments as the technology is de-risked. And so as it's de-risked, the milestone payments get higher and higher. They also are looking to earn royalties. So in the early years, the first 5-7 years, I really think the upfront and the annual payments are quite reasonable. I haven't seen them to be unreasonable. A typical US deal will definitely include patent reimbursement for an exclusive licensee. Even as Tony says, Stanford and Cambridge are well endowed, the office usually needs to pay back its own patent expenses. That's usually the biggest concern for an office. And so again, the office has invested in particular IP expenses. And if the startup is to acquire a license to them, the expectation is very clearly that the startup company will pay for those patent expenses and for future ones too.
Understood. Tony.
Yeah, I think sort of we need to differentiate between licensing to major corporates, where one would do a sort of a full commercial deal with upfronts, minimum annual royalties, et cetera, versus a startup, which we said are cash poor. And for Cambridge startups, we're lucky because of the funds we have to deploy. But for a lot of university funds, $10,000 is a lot of money, and that's better put towards growing the company. So I think tendency is more to not try and take cash out of the company at these very early vulnerable stages. We expect to move on the costs of the IP to the company if it's an exclusive license, not if it's a non-exclusive one. But we do expect them to take up patent costs. And but beyond that, I think we are much more focused on the back end. If this is a success, we share in that success with you.
So the difference there, Kathy, is probably a reflection of just the more ready access to capital and funding that the Stanford spinouts have. So you can afford to, in effect, say, pay to play. and be a bit more hard-nosed about charging the access fees or the upfronts?
I haven't, but while at Wilson, I haven't seen any deals, any startup deals, which didn't include an upfront original fee for the license.
Interesting. And Kathy, you raised the interesting point about what happens if there's more than one IP asset which the startup needs to in-license. And typically you might have foundational IP or something fundamental to the startup business plan. And then there might be some IP which is nice to have. In those situations, in the US, do you typically try and find, and particularly if the second set of IP assets come from a different institution, do you typically try and coordinate that through a single licensor to avoid the risk of doing two parallel deals and having accumulation of upfronts and royalties and all the financial payments and the equity stake? Or how would you recommend that licensors, academic founders, licensees and academic founders should manage that risk?
So, of course, at the beginning, we would recommend that a startup do a, patent landscape or IP landscape and see what technologies they think they're going to need. Typically, a university is not really paying attention to what's happening to other, the same area at other universities. So ordinarily, we would rely on the company to know what IP they're going to need. If there's joint collaboration, let's say, where there's two university researchers working together, joint IP that a company is interested in, the universities would coordinate. That's very, very typical. It's an interinstitutional agreement. One of the universities will take the lead and negotiate with the company. But if they're disparate intellectual property pieces that, let's say at Stanford, I don't know that someone at MIT is doing something similar, which the company needs that IP, we would not coordinate all this. The company needs to think about all the IP it needs to acquire and figure out the financing to pay for each piece if they're not, originally coordinated in the first place.
And if the company sort of educates the office and says, we need these two pieces of IP, we can't give 30% equity to both universities because, even though that's what they'd ask for if it was a standalone spin out, we cumulatively, that doesn't make any sense on the cap table, as Jamie was saying. Would the university be sympathetic there, or would it stand back and say, well, it's up to you to work out how to finance this?
I think they would be sympathetic. What the company needs to explain is, if it's founding technology, a university will think it's more valuable. If it's nice to have technology, a university understands that its value isn't as essential to the company. And so, again, I think universities are willing to listen to the story that the company has to say, and they need to make the argument why a particular financial package makes sense or doesn't make sense in the context.
Sure. And Jamie, if I can bring you in on this one, what are your attitudes towards situations where you've got IP coming from more than one institution, more than one source? How do you recommend that your investee companies try and handle it? Hello, Jamie. I think Jamie might have frozen, so we'll come back to him. Tony, have you seen this either with other European universities or with other UK universities?
Yeah, we've seen it with universities around the world. And I think going back to what we're trying to do is create the best possible impact. So we want to facilitate that as much as we can. Where it is sort of as a result of research collaborations, we will sort of generally try and work out who's best placed to take the lead on it as a university and agree the terms between us and let one person negotiate. But quite often, these companies, who are setting up they've got their own team on there. They know what they want, and they prefer to go out and negotiate it themselves. But at the end of the day, this is not something which is unfamiliar in the general startup space. If you need your IP, you need to negotiate with it, and you can't give away 100% of your company for what you need. The more interesting things, I think, are around two things: pipelines. What rights and access do the spinouts have to the ongoing IP from the research of the university in that area? And so we like to keep those narrow to the research group and time limited. So that's quite a sort of a tricky one. The other thing we need to be careful of is when working with other universities, is we're not creating cartels, that we're sort of bundling everything together and being anti-competitive in the way we're operating. So there's a number of issues which go into that. But sorry, the other point which was just slipped out of my mind, come back to, is also the research link with the university. I think one of the big differences between the US and the UK is we are much more comfortable managing the conflicts of interest of a spin-out company continuing to be involved with research from its founding research group, which is generally, certainly in MIT and Stanford, I believe, is not allowed. And obviously, in that case, sort of there's more IP coming out all along from sponsored research, which has contractual rights of transfer associated with it. So it can get complex. But again, both sides of the Atlantic tends to be a different approach because of conflict of interest philosophies.
Sure. Jamie, are you back with us now? I think you're unfrozen.
I'm back. Yeah, I mean, I think a majority of what was said kind of highlights it. You know, it's hard to bring everyone together to do stuff, and you want to really be careful and thoughtful about how you go about structuring, multiple IP and things of that nature, just because a lot of this is very hard to undo, and it can have some real consequences going down the line. So doing something in a rushed manner in the very beginning, because it's the most quickest way to that answer. Sometimes you always have to get it right. So do you want to do it now while maybe the paint's still wet or the clay hasn't set, or do you really want to unwind and unweave some of the relationships between all the different partners that are coming together later on? So it's just easier to be really transparent, really open, and realize that all sides are trying to move in a common direction. So you all have to start rowing in the same way at the same time to get anywhere.
Great, thank you for that. Right, we're coming up, time is ticking by, and we've got some interesting topics still ahead of us, but we're getting, I think, a lot of interesting issues. And Tony, you mentioned pipeline agreements just in passing there. So if we move on to deal structures, where on the slide, we talk about licenses versus assignments. And then just picking up on a couple of the questions, if we can add into the discussion options, in particular options to take a license, and also, I guess, pipeline agreements, and deal with all of those together. I think basic question, Kathy, in terms of assignments, my understanding is in the US, it's almost never happens. In fact, probably never following Bayh-Dole happens that the university will agree to assign IP. Is that correct?
That's pretty correct, yes. I don't know of any university that assigns IP. Under the Bayh-Dole Act, the university has the right to retain title if we do certain things. But then if we decide not to file, then title goes back to the US government. So it's not as if we even have the right to assign a license.
And that's in relation to federally funded research?
Yes. And because many universities would be uncomfortable with, being very, very clear whether something is federally funded or not federally funded, most university intellectual property policies say that the university owns the IP regardless. And most tech transfer office will want ownership, and only want a license because they want to make sure the technology is being developed. And so again, if the licensee is not developing the technology, the university typically wants to be able to take back the license and theoretically license it to somebody else.
And what about pipelines, Kathy? What did you do at Stanford with pipelines, and is there a US practice in relation to pipeline agreements?
As Tony said, I think the US is very concerned about conflict of interest. At Stanford, we would grant an exclusive license, let's say, to the first technology. If there were, from a patent perspective, what we call continuing applications, on occasion, we would give rights to, improvement technologies for a set period of time, and typically it wouldn't be longer than 2 years. But from a conflict of interest standpoint, the conflict of interest people really want the researcher to be able to separate the research that's being done at the company versus the research that's being done at the university. And again, the typical policy is that university resources should be used for university purposes and not for commercial purposes. And so again, the universities typically want a very clear distinction between what's going to be done at the company, the development work, et cetera, and basic research done at the university. So most US universities have a conflict of interest policy and a practice, and they will review the situation before they even are able to do a license. Again, typically, universities will want the researchers to be able to separate it, make sure that students get the best academic training that they can, and that this training is not influenced by personal commercial gain of the faculty researcher.
And when there is a pipeline agreement with the appropriate caveats and limitations around it, is that an agreement with an option to include that IP as licensed IP on fair and reasonable terms, or is it simply an option to that is deemed to be licensed without further payment?
Well, my experience at Stanford and the universities that I've worked with in this kind of, future IP thing will not offer an automatic option to future technology. I mean, the language in the original license will say the licensed patents include, the patent as filed and maybe continuations that rely on the original specification for a period of 2 years, let's say. Now, we don't usually have a per se pipeline agreement. Actually, at Stanford, we ordinarily did not take sponsored research from a faculty startup company so that there would not be the ability to even have the future research funded by the startup company and those inventions coming back to the startup company. And then let's say the faculty is really just still doing basic research in an area that might be of interest to the original startup company. As those new inventions come up and they're not under some definition of the original licensed patent, then we would shop the deal. We would tell the world about this new technology. But at the end of the day, it probably would make sense to license it back to the original company if the original company has sort of background IP. So again, it's usually a very practical look at the situation with no upfront promises.
Okay. And Tony, that sounds fairly similar to our anecdotal experience of what goes on in the UK, and in particular here in Cambridge. Is that right?
Yeah, I think we try, in terms of pipelines, we try and limit the time period. We limit the scope, and we also limit it to individuals so that we're not taking IP generated by other research groups across the university and putting it into a company they've got nothing to do with. So that side, I think, is fairly similar.
But again, is just coming into the specific point, for future IP which is covered and arises under the pipeline agreement, is that to be licensed for free, basically without further consideration, because under the pipeline agreement the research has been sponsored? Or do you enter into pipelines where there is no funding of the research and the IP is then to be licensed in return for a future payment? Or do you have the best of both worlds from the spinout's point of view, where you can have an agreement, a pipeline agreement, with no sponsored research and no further payment? It's just automatically deemed to be included under the original license agreement.
I think you see all of those different flavors. And you can see that the pipeline agreement, really, the investors want it, because what they don't want is the academics coming up with a brilliant new idea the day after they invested that's going to obsolete the whole company they've just invested in. So you can see the investors want the protection from the academic group. But it depends, sort of, obviously research is going on from government funding. Some of it is going on from, we do allow our spin-out companies to sponsor research in the research group from which they originated. And in that case, it will be down to the contract terms. So I think it really does depend on the individual circumstances and the investor requirements, etc., to work out a deal that's going to work for everyone.
Sure.
But we do like to keep the pipeline short and narrow, if we have them.
Yes. Well, in the time that's available, we've got 3 minutes left, which isn't really enough time to do this to the last topic. But we have had a question about know-how, transferring know-how, which I think touches on one facet of what we were going to speak about in relation to non-traditional spin-outs. Where there is an invention arising in the course of university research which isn't patentable, either because I guess it doesn't meet the criteria or because it's not patentable subject matter, but it could be protected as know-how. Can you say just a couple of thoughts each, and Jamie, do chip in as well, about, is that the basis for a viable university spin-out, or is that actually just too difficult to manage? Because presumably there would be you might license know-how on a non-exclusive basis, but if it were to be exclusively licensed, there would have to be some confidence within the university around keeping that confidential. And it may be that the universities don't feel confident that they can deliver on that type of confidentiality undertaking. Kathy, can I start with you? One or two thoughts.
From a startup perspective, you want the know-how to be very, very well defined. Because again, often a license, if it includes know-how, there will be some sort of, there's a possibility of a royalty obligation along with the know-how. I mean, if a startup gets a know-how license that runs in the time frame of let's say, an additional patent license all together in one agreement, and you don't have to continue paying on know-how, I think that's good, and that would work. But if there's some tail where the patent expires and then the company has to pay on know-how after the patent expires, then you really, really have to define the know-how very, very clearly. And that's often the big challenge, that the know-how, well, universities don't keep know-how as trade secret very well. So again, it has to have added value and given the company some advantage, or the company shouldn't be paying on this know-how.
Thank you, Kathy. And Tony?
Yeah, I think you can. I think know-how is an undervalued IP asset. People think all the time about patents, but know-how, it can be quite a valuable asset. It's like Kathy says, there is a challenge in the universities. We're not the most watertight places for ideas and thinking. We do have this publication imperative that everything that we research is published. So it tends to be less that we've got some great idea that we're not telling anybody about, but I think more it's knowing how to make things work. It's all the tricks of the trade and the sort of 20 years of experience, which is the know-how, rather than sort of the Coca-Cola formula, which we keep secret and tell nobody about.
Sure. Jamie, presumably in the life sciences, it's patenting or bust. You wouldn't be interested in investing in anything that's purely know-how based, at least.
That's not necessarily true. I think know-how is good when you see a direct line into composition of matter and harder defendable IP. So, for instance, one of the companies that I've started actually is built mainly around know-how. We thought it was clever enough technology that we well defined where the boundaries of what the applications would be. And it was, basically how to kind of feed in and give us a jump start to later develop more solid, more concrete IP. I wouldn't say we would, if there wasn't the promise that this could get us some composition of matter, which in biotech, if you're dealing with IP that's not going to somehow generate composition of matter that's a hard, tangible asset, then I would question why do it. But it's, it's a nice to have. It's not always a need to have. And it really just comes down to what the technology is. I would say, if you can well define the application and maybe you do want to get a little bit something stronger than trade secret, especially when it can be broadly applicable and that academic university likely will be doing a lot of publication, it just gives you a little bit more protection around very, very new promising technologies. But, if there's small add-ons later on, I'm not quite sure how much value it has, but if it's super early, it's worth, I wouldn't say you wouldn't start a company. It just has to be a very specific type of company that you would start, probably a very broad scoping platform company.
Sure.
Yeah, and I think
Good.
when you look at know-how, the value of know-how is really how much time and effort would it take a competitor to actually develop their skills to be able to do the same thing. So that's the financial barrier that protects.
Yeah. You're really locking up the academic university to buy you more time. The secrets will come out over time in publication and other people going to conferences and seeing what they're doing and tweaking it. But at least in the very early days, it buys you some early protection for you to figure out where the fences are for the IP strategy for the company itself.
Sure.
Well,
good.
I also want to remind everybody. I wanted to remind everybody that know-how is often in the minds of the researchers. So a company can acquire it through consulting.
Yeah, that's a good point. Really good point there, Kathy. And a good point to finish on. I think we've come up against time. We've overrun very slightly. It's been a great debate, I think, with a real flow of ideas, and we could continue almost indefinitely, I think, but we won't because we've come up against time. I'd like to finish by thanking Kathy, thanking Tony and Jamie very much for dialing in and taking the time to share their thoughts with us, thanking everyone who has joined us remotely to take part. We've dealt with a lot of the questions, but not all of them. Where we haven't dealt with the questions, we will follow up afterwards. Thank you very much for your participation. A very quick reminder that there will be a short survey when this webinar finishes. So if you could take 30 seconds to give us your feedback, then we'd be very grateful. And other than that, it just remains for me to thank everyone for taking part and wish you a good afternoon, good evening, depending on where you're dialing in from.